We have with us Professor Dr. Ishwara Bhat, the former Vice Chancellor of Karnataka State Law University, Hubballi, and the West Bengal National University of Juridical Sciences, Kolkata. Sir was a Fulbright Nehru Visiting Professor in 2010 and involved in co-teaching NPO laws at Columbus Law School of Catholic University of America, Washington, D.C. He was also a visiting professor to Queen's University, Kingston, Canada. He was a recipient of Shastri Visiting Research Fellowship in 1992 and researched on comparative study of language rights in India and Canada in the universities of York, Toronto, and Ottawa. His publications include highly appreciated books on law and social transformation in India, idea and methods of legal research, fundamental rights, a study of their interrelationship, and many more. He has also edited innumerable books and journals and published a plethora of research articles in legal journals of international and national repute. He has presented his research work on various national and international platforms. His area of interests include constitutional law, administrative law, social change, water law, and research methodology. He has also guided many PhD scholars in a variety of legal studies in the University of Mysore and West Bengal University of National University of Juridical Sciences, Kolkata. I request our faculty, Ms. Shefali ma'am, to kindly hand over the bouquet to our guest. Thank you, ma'am. I would like to invite Professor Dr. Ishwara Bhat to kindly deliver his address on method and methodology and exposition of various research methods.
First, let me thank Professor T.R. Subramania and his colleagues for giving this opportunity of addressing the learned gathering here about research methodology. A national seminar is organized, and from the morning itself there is a theoretical discussion about the nature of legal research, then the concepts involved, and various other aspects. You might have understood that basically it is a purposive intellectual activity aiming at generation of knowledge in relation to a specific subject, thorough, systematic, and exhaustive study of any subject or a topic, resolving or trying to resolve any research problem. That is the task that is involved in a research activity. Idea of research is that, and it will go beyond that because there is no such a limit to it, and it is a purposive, and knowledge is also purposive. Knowledge that is generated through research is something to bring welfare to the society, or it is to bring some legal reforms, social reforms, or bring awareness, and bring a kind of social transformation itself. Thus, a knowledge system and the intellectual exercise of research have that kind of aim at certain social purposes to be satisfied, and the techniques or methods that are used in the context of research should satisfy the purpose of research or the basic aim that through research, truth is to be unraveled, or a new idea or new knowledge shall be brought out, or overall reform of the society should be possible. So, method has a very important role to play. Between an idea and method, there is always that kind of interaction, because once you choose the idea, you choose the idea of conducting research or conducting research on a specific topic, then in relation to that topic or that type of research, whether the method that is chosen or that is going to be chosen by you is appropriate or not. About that, when analysis is conducted or when a discourse takes place, that kind of discourse is called as a methodology. See, methodology contains two words. One a method, the other is a logy or a science. Science of methods. Method, that also contains two things. Meta, how does. The way of doing things. What is the exact procedure of conducting a research activity. So, the method shall be appropriate, and it shall be something that really is relating to the concerned topic. I mean, it should be suitable to that topic, because we will have several methods of conducting research. Insofar as legal research is concerned, it's broadly possible to classify into three categories of methods that might be employed by the researcher. One is a library-based method, or a method which uses the knowledge resource available in the form of books, journals, articles, or any of the information that is available in internet, etc. So, library-based. There we come across a doctrinal method, analytical method, historical, then a comparative, and a philosophical method. Then we come across a empirical method, where experience-based learning is the method that is chosen by the researcher. Experience-based. By surveying the society, or by understanding the society in its natural setting, on the basis of the views collected by the members of the society, either through interview or questionnaire or say observation or case study, etc. Through all this means, suppose the intimate, natural, and free views of the people, or free views of groups are collected and they are analyzed, and when certain observations are made on the basis of such a analysis, then we say that it is an empirical study. Empiricism stands for that kind of evidence-based activity, evidence-based intellectual activity from the side of the researcher. And primarily it is of two types. One is a qualitative research, the other is a quantitative research. Related to quality, it is the word of the society, word of the individual, or the behavior, or the actual expressions. All these things enter into the process of analysis from the side of the researcher. That is a qualitative research. A society will be understood in its natural setting, and its intimate use, or its heartfelt views or thoughts or ideas. These are brought to the knowledge of the researcher, and the researcher makes use of that knowledge or those data or those facts and makes analysis. There is a qualitative research. See, there we find that the evidence collected is directly from the society, from the people, and from the natural setting of the society. That's why it is a qualitative. The evidence is qualitatively of a high order. It is not something based on hearsay. It is based on sociological study. It might be case study, or it might be survey, or it might be observation, or say other types of studies like focus group discussion, etc. But it is from the heart of the society that those reviews are collected. Quantitative legal research is something focusing on the statistical data, or its concern is about numbers, because so many factual circumstances can be examined from the angle of the purposes. Thus, the purpose is something that will, the purpose of a social action is something reflected through the digital facts or quantitative facts, and their collection of all such statistical information. That is the first step, either by census or by survey or by questionnaire or other means. The researcher will be collecting all such information, and this is the first step. There is a collection of data. After collection of data, the researcher will be organizing that data. There is a systematically classifying that data, and treating that data in such a way that coherent analysis of that data will be possible. That's the outcome of organization of data. Then comes a presentation of data, presentation by say tabular presentation, or a graphic presentation, or it might be presentation through various other types of statistical expressions. That is a presentation. After presentation, the matter will be analyzed. All those facts which are properly classified or which are properly organized and available in the form of say bar columns or tables, curves, or other types of expressions, that will be analyzed by the researcher. After analysis, then comes interpretation. See, analysis is also through application of some statistical methods or a statistical formula, and interpretation is also by using some special methods like say use of certain specific formula, chi-square test, or various other types of tests. And after such interpretation, he will be passing certain remarks or conclusions, or drawing certain inferences. That's how COPI. There's a collection, organization, presentation, analysis, and interpretation. These are conducted in the course of a quantitative research. Then these two methods, there is the library-based methods. Usually, they are classified as a doctrinal methods. Doctrinal method, in ordinary parlance, includes all types of such approaches, which include analytical approach, historical, comparative, and philosophical. But doctrinal has its own method, about which I will discuss later. Doctrinal method and empirical method, these are two mutually complementary. It is not possible to say that they are opposing each other. Between the two, the relation is one of mutual assistance and mutual rectification also. If some observation based on a doctrinal study is something to be checked by means of using a, say, empirical method, that empirical method will result in, application of that method will result in, say, appropriate conclusion, rectifying some of the inferences that are drawn on the basis of this doctrinal study. For example, under Criminal Procedure Code, there is one legal prescription saying that within 60 days from the date of filing of a charge, a rape trial shall be complete. That is the mandatory provision. And if we go by that legal principle or a doctrine or that legal proposition, then we will be arriving at a conclusion that yes, the legal system is fantastic. Within just 60 days, rape trial will be complete. That is a very laudable feature of this legal system. About that, there could be a lot of appreciation. What is the reality? When we gather the social facts on the basis of application of various tools like a questionnaire observation or interview and various other methods, or gathering of data from the courts where those cases are pending, then the reality is that in all the 15 or 20 cases that are taken as a sample, the position is that in none of the rape trial, the trial is complete within 60 days from the filing of the charge. It is much more than that. Minimum is about 80 days, maximum is about 3 years also, and average is about more than 1 year. See, this kind of factual verification about the legal position can rectify our estimation of the legal system. That is why I said that empirical method can rectify the inferences that are drawn on the basis of doctrinal legal research. Then empirical method cannot be conducted independently. See, it is with reference to some legal problem that the research is conducted. Then the researcher should know what is the legal position, what is the content of the provision relating to acid attack, or about various other provisions, say dowry prohibition law or section 498A of Indian Penal Code or such things. First, he should know what is the law. Then he can understand how that law is put into practice. That is why non-doctrinal legal researcher or empirical legal researcher should also know thoroughly what the law of the land is. That is why non-doctrinal legal research and doctrinal legal research go together. there is no incompatibility between the two. On the other hand, there is a mutual dependence between the two. And the task of knowledge generation will be possible only if both the methods are used. That's why the researchers go for an integrated method. They use a multi-method legal research. Multi-method legal research means that the legal researcher will be using more than one method. More than one method, either in the first category or second category, or both the categories are put together. Multi-method legal research. The advantage of multi-method legal research is that from a different viewpoints or from a different angles, it is possible to evaluate the legal phenomenon which is under the process of research, whether the concerned legal institution or a legal procedure is operating satisfactorily or not. That can be assessed on the basis of application of different methods of legal research. There is a multi-method legal research. For example, doctrinal method, which primarily makes use of the doctrines laid down under the precedents or judicial decisions, and examines the whole legal development on the basis of case law, can be better undertaken if adequate historical study of the whole legal development also is done by the researcher. Then, without analysis, the precedents cannot be properly examined or evaluated, or the flow of those precedents, what is the trend of legal development through these precedents. About that, it is not possible to arrive at a particular conclusion unless we know the historical background of that legal proposition or a legal principle. Then, if we have experience of other countries about the performance of a particular institute, particular type of institution, or mode of a procedure, or mode of a certain legal principle, then it is possible to comparatively evaluate what is the experience of other systems as well. For example, about a parliamentary form of a government. So in some other countries, the practice is that because of a strong party governmental system, there is a party cohesion. There is no problem of say political defection, and because of iron discipline of the political party, everything is in accordance with the true and fundamental principles of parliamentarism. Then of course we will be able to contrast with that system. UK system stands for that. So we contrast our own system where defections, political defections take place, not on the basis of ideologies, but on the basis of say allurement of a power, or say impact of a corruption, or so many other things which are the reasons behind a political defection. Then we have to test the efficacy of the parliamentary form of government, and even the newly framed scheme like a 10th schedule to the constitution is whether that is able to provide effective remedy or not. About that we will be able to evaluate. What is the experience of other countries, our own sister nations like Pakistan, Bangladesh, or Sri Lanka, or say South Africa, or other countries where again democracy has not attained so much of a maturity, or a party governance has not attained so much of a cohesion. What is the experience in those countries? So we are able to compare and contrast with those positions. We will be able to evaluate our own position. That's the comparative study. And for a doctoral study itself, that comparative study becomes very much important, because experience is not always based on one's own experience. See, for learning that Syncona is something very useful for a disease like malaria. It is a panacea for malaria. That type of proposition could be understood on the basis of somebody's experience. It is not necessary that we should grow the Syncona tree at our backyard and apply to a person who has suffered from malaria, and only on that basis will be announcing to the whole world that Syncona is the best medicine for malaria. Why need for waiting our own experience? Because human community in some other parts of the globe, on the basis of their own experience relating to certain institution, procedure, or legal principle, have certain type of experience. Why not make use of that experience? That is the idea underlying a comparative study. Then mere legal principle and legal analysis may not be always be providing for adequate input or insight. There are certain abstract principles. When we explore about the concept of justice, or a concept of liberty, or privacy, dignity, or various other concepts, or good governance, or fraternity, etc., then on the basis of the scientific understanding of facts, suppose the researcher can make certain conjecture about the philosophical dimension of that, then he can guess about the possible answer in the domain of philosophy, and that's a philosophical research. Because when a researcher conducts a research on the basis of facts, at some level, some mature understanding of facts will be there, but that itself cannot be regarded as sufficient, because concerning some of the deeper questions about the very basis of justice, the very basis of family, the very basis of say human right or harmony, etc. So some questions are there. Those questions are to be philosophically discussed and philosophically answered. That is why philosophical study becomes quite appropriate. See, philosophy is a love of wisdom. It is not something abstract metaphysical study. It is something based on the actual experience, but going beyond that in a generalized manner. What could be the appropriate approach? About that one will be conjecture. See, when the university awards a PhD degree, Doctor of Philosophy, it recognizes that the concerned candidate can be recognized as fit for particular recognition for the reason that he has mastered certain skill of exploring the philosophical underpinnings of any new concept which he makes inquiry. See, this is how various methods of legal research are interrelated. They are interrelated, and of course, horizontally also there is that kind of interconnection. See, I said about multi-method legal research. Here, the researcher will be using more than one method. It might be different methods under the first category, or some of the methods in the first category and some of the methods in the second category, qualitative research or quantitative research. Now suppose about section 498A of Indian Penal Code, a researcher conducts research that is relating to cruelty by the husband by using say dowry as an exploitative means against the wife. All the persons, the husband and husband's family members, who make any kind of harassment of the concerned woman will be declared as guilty of offence under section 498A. Suppose there is a complaint that there is abuse or unnecessarily or in an unjustified manner complaints are filed by women, married women, or suppose about the efficacy of that provision itself. There is some doubt or there is some need for further clarity. Then the researcher will be using more than one method. There is a what is the whole trajectory of a case law pertaining to section 498A of Indian Penal Code. What are the procedural issues, how those are interpreted, and relating to interpretation of section 498A, what are the provisions, about right to bail and various other matters relating to section 498A, what is the case law development, and under article 15(3) of the Constitution or article 21 of the Constitution, how they are interpreted, about that also there could be discussion. All those theoretical discussions would be there. In addition to that, taking some district as the universe and conducting a research about the section 498A cases in various courts of that district. There is various taluka courts or district courts. About all those things, suppose data is collected by going to all those victims as well as accused persons, then police officers, investigating officers, then having interview with the public prosecutor or having interview with the defending counsels or having interview with the judge or other officers of the court. Suppose through these means he collects a huge amount of data, because district is a big universe, because the population may be about say 50 to 20 lakhs, and the area is also quite big, and data collection may not be that easy. Usually the researcher should confine to specific areas rather than such a big area like a district, but still compared to state or compared to the nation as a whole, district is a smaller unit. But suppose he has collected all such data by use of sampling as a method, and then of course here he makes use of qualitative as well as the quantitative method along with the doctrinal method. About a section 498A of Indian Penal Code, whole of a case law and its development, all those things are surveyed there. But about these practical issues, how much time is taken for conclusion of this trial under section 498A, and whether such a process results in conviction of that person or acquittal. In what number of cases there is acquittal, and in what number of cases there is a conviction. On what ground that acquittal takes place, and if conviction takes place, what is the quantum of a penalty imposed, for how many years or how many months that the concerned person is put into prison, or how much of a penalty has been imposed. About all those things, he has to collect the data. That's why quantitative data is also collected. See, here the researcher is making use of more than one method. The advantage is that the shortcomings or inadequacies of doctrinal research can be made good by having a realistic perception arising out of qualitative and quantitative research or empirical research. That's why Law Commission makes use of multiple methods of research. See, relating to say plea bargaining, or amendment to section 6 of Hindu Succession Act. When a Law Commission conducted its research, it made use of a multi-method. See, it formulated a working paper relating to the subject and distributed, asked for comments from the general public. It distributed a questionnaire so that from people it could get such responses in time. Then it organized various seminars in different places, gathered information from the academic people or other participants, so that about the advantages or disadvantages of different types of legal provisions, it could make some analysis. See, the information that is collected could be quantified. There's how many persons responded in this way rather than in that way. What was their qualitative use? About all those things, whatever data collected by the Law Commission is something used along with historical study. See, what is the background of section 6 of Hindu Succession Act? What is the sociological background? See, section 6, as it stood originally, had provided for recognition of a co-personality, and also protection of rights of women in other sections. Then, when a big change is to take place, so that a co-personality system itself, that concept itself is going to be altered, so that daughters will also be considered as members of that family, and they are also entitled to right by birth. Then it is a big change. And what is the people's view about that? What is the public opinion? How exactly the common people react to that? What are the difficulties or criticisms that are expressed by various sections of the society? When all such data is available, socio-legal research of a real type will be possible, because the researcher, the Law Commission, is going for that kind of a multi-method legal research. It looks from different angles. It looks from the angle of say males or females, or from the angle of the history, from the philosophical angle, and it makes use of analytical study, what is the constitutional philosophy, and in the light of that constitutional philosophy of gender justice, can we consider discrimination between a son and a daughter as appropriate? And if after a period of almost 50 years, when a change is going to take place, what should be the change management? How exactly that change is to be planned and how it is to be executed? About that, the researcher will be getting information from different sources. Then comes a policy research. What is a policy? Policy is a community's aspiration. Collectively, when a community aspires for or expects certain kind of approach towards any of the public issues, then we say that that kind of approach is a policy. When the government adopts a specific policy pertaining to the community, it tries to preface it through various methods of analysis, whether that policy is appropriate or not. Formulation of a policy, evaluation of a policy, then estimation of the effect of that policy. All those types of analysis a researcher conducts is concentrating on that policy. Policy is something different from a principle. Principle is a legal proposition, a norm which gives rise to rights and obligations and are enforceable. Whereas a policy is only an approach. And when that approach or that policy is elevated to a legal proposition in the form of enactment, then it becomes a law. A legislative policy takes the shape of a legal norm because of the acceptance of it by the legislature. Whether that policy is appropriate or not, that is a question to be decided by taking into consideration various factors. See, the researcher takes into consideration several alternative policies. Now, suppose relating to regulation of extraction of groundwater. Different states have different approaches depending upon their topographical, geographical, or rainfall, climatic and other conditions. And of course, it is the reality of economic geography ultimately decides about the propriety of any specific policy. Thus, alternative models are there. One is a model which states that no groundwater shall be extracted by any individual without the permission of the government. Everything shall be according to the regulation, strict regulation by the government. How much can be pumped and for what purpose it could be used, and what is the duration of that pumping, and who can do that, For what purpose? About all those things, it is the government that decides. That is one approach. Another approach is to allow the people to extract groundwater according to their whims and fancies. Any amount of groundwater can be extracted. There is no control, no limit. Anything can be done. And the owner of the land is the sovereign owner of all the resources under the earth, and he has that right. That is another thing. And between the two, there will be various other policies. There is a system of licensing. There is it can be done, but only subject to the license issued by the government that extraction of groundwater would be permissible. And another would say that there shall be adequate measure to control extraction of groundwater. Further, there should be measure for augmenting the groundwater resource by rainwater harvesting or afforestation or various other policies. So different models might be there and based on different policies. So the researcher has several choices to make. Policy choices are several, and among different policy alternatives, which policy can be regarded as appropriate? What are the advantages and defects of each of the policy? About that, so he conducts a research. There, not only the legal principle and administrative directions, but even about the social experience and the people's approach and the people's practice and the practice of various other agencies like electricity company, etc., are also taken into consideration. Then we say that there is a multi-method legal research, and always a policy researcher has this approach. The researcher has to evaluate various alternative policies. First, he has to map all the alternative policies. Then, after mapping all the alternative policies, then examining the advantages and disadvantages, pros and cons of each of the policy. That is the thing to be done. And how exactly he has to evaluate it? He should have certain criterion. Which is the criterion? That criterion could be conservation of resources. Conservation of natural resources might be the criterion, or long-standing availability of this precious resource like groundwater. That might be the criterion with which he will be testing which policy could be regarded as appropriate. And here he starts with the different policies or different questions. Whether this policy is appropriate or that policy is appropriate, or number 3 is appropriate, etc. He is not concentrating on one single question. That's why the method is different. See, in case of doctrinal research or various other types of research, usually the approach of the researcher is unilinear. There's on the basis of doubts or the felt necessities or difficulties of the time. Suppose a question is raised, some question is raised, and that question is converted into a research question. And after converting that research question, suppose a possible answer to that research question is tossed in the form of a hypothesis, and then that hypothesis is tested with it. In the light of vast data that is collected pertaining to the subject, and further analysis is made, and on the basis of certain testing of hypothesis, suppose some conclusion is drawn. here it is the normal type of unilinear method of legal research, and most of the researchers it is like that. Take one research problem, concentrate on that issue, and examine whole of those things. Here, in case of policy research, there is a diversity of various policies. Which policy is appropriate? Of course, that question might be a single question, but diversity is there because of the implicit character of different choices available to the concerned individual. But there should be some perspective, and there should be criterion with which one will be testing the validity of that policy, and which policy could be regarded as viable, appropriate, and suitable to the community. About that, he has to pass certain remarks, he should draw inferences, and for all these things, he cannot afford to have unilinear approach. Multiplicity of policies are to be evaluated by the researcher in such circumstances. That is called as a policy research. Then we come across action research. See, when along with the research, action is also something contemplated. There is a different type of research which makes use of certain methods through which that action can also be ensured. For example, human trafficking is a problem in a certain border districts of say international boundary, either in West Bengal or Bihar or some other places. Suppose that problem is experienced, how exactly that is to be dealt? And of course, the researcher goes to the spot, not only resorts to doctrinal research of collecting all such case law, statutory provisions, and executive's power relating to control of this problem, etc. But he goes to the spot, he makes a survey, he contacts various victims of human trafficking. Of course, it is not possible to have such a direct access to either the victims or the perpetrators. That is why the researcher may find it wise to have access to those persons through some NGOs, because NGOs have some connection, or some other agencies might have connection, and through them, suppose he collects the data. See, he comes across certain situations where some girl child is abducted, kidnapped, and kept in detention for the purpose of human trafficking. 2 or 3 girl children are, say, kept in a confidential manner, incommunicado. They are kept in a particular place, and he comes across that kind of a factual situation. As a researcher, should he confine himself to survey of facts and making a report to the concerned funding agency or to the government that such things take place, etc., and after some span of time he'll be getting a PhD degree or some other recognition, etc. That's a different thing. But suppose he confines only to that, then does he perform the real social responsibility on the part of an intellectual? As an intellectual, he has that kind of responsibility to rescue those unfortunate victims. And in such a situation, suppose he explores the possibility of getting a remedy through administration or through NGOs or through persuasion of those members of the family, empowering, strengthening or encouraging them so that they would be able to get some legal remedy also. Then of course it may be quite appropriate. Or suppose he files some petition so that the High Court or say the administration may immediately interfere and provide certain remedy so that those people could be rescued. See, here the researcher, along with his usual research activity of collecting data, then making analysis of those data and giving report, he will be making a kind of a social contribution in the form of rescuing these unfortunate people. This type of research is called as action research. See, action research is something popular in institutions like National Child Rights Commission, National Human Rights Commission, National Commission for Women, and such other commissions. They make use of this action research, and the government is also nowadays in favor of action research. See, central government's Ministry for Law and Justice is providing scholarship or research projects for such action research. Element of action research should be there. Then only there will be such a funding, because research is an activity which gives rise to a lot of new facts and new knowledge. It generates a new knowledge. Suppose there is a knowledge about a violation of a human right of some unfortunate victims, then providing a remedy to those persons at that level, in the beginning itself, or in a right time, that becomes quite appropriate. One need not wait until the submission of this report to government. Then the government may or may not consider that report, and then subsequently there might be alerting of police, etc. By that time, this process of trafficking of these unfortunate victims might be complete, and they might have been shifted to some other place. See, very timely intervention by the society or by the community is essential in such circumstances. Action research is quite effective. Then we come across feminist research. This also makes use of multi-method. Action research makes use of multi-method. There's a doctrinal research, then qualitative and quantitative research, and there are also using of not one single tool, several tools. There is also multi-method. See, if interview is the exclusive method of conducting research and getting data from the interviewees, then we cannot consider that it is a safe thing to rely upon the data collected through interview alone, because some other data which is available in a government, or which is available in a public record, or which is available through social survey, may be controverting the statements made in an interview. Sometimes the interviewees may exaggerate, or they may suppress or they may not disclose all the things. In such circumstances, the infirmity of that data can be cross-checked by taking into consideration data available in some other method. That's why application of different tools of data collection that can be resorted to along with the use of observation study. There can be study, there can be case study. See, by going for a in-depth analysis of the factual background relating to specific institution or specific person or a specific process, it is possible to know what are the advantages and disadvantages relating to that, what are the difficulties there, or whether the social circumstance involved has something relation with some other factor. Now, suppose a case study is conducted about the position of domestic workers. Usually domestic workers are either girls or women. They are employed as domestic servants. Now, suppose about the position of domestic servants, that's the legal position of domestic servants or legal protections that are available. Study is conducted that is relating to, that employs non-doctrinal legal research. Doctrinally, all such information is there, or he will be collecting that data. They are unorganized labor, and under maternity benefit law or sexual harassment law or various other laws, what type of protections are available to domestic servants. About that, such a doctrinal study will be providing input. What is the reality? Whether they are paid minimum wages, whether they are paid, whether they are given a leave, there is a leave with the pay, weekly leave or monthly leave, then whether they are getting various other benefits, whether they are paid salary regularly, and of course, various such issues might be there about their position as workers. But suppose they are subject to exploitation, sexual exploitation or physical exploitation or other types of harassments, then what type of protections are available? About all those things, just on the basis of a survey or such a things, it is not possible to get information. It is essential to go for case study. Through case study, it is possible to know what are the individual difficulties. Suppose that a girl child who is working as a domestic servant is actually a child labor, or suppose she is married, then there is a situation of a child marriage, or if there is a situation of sexual exploitation, there is a need for application of Vishaka principle. See, case study goes on unraveling so many type of factual situations. Then comes a feminist research that also requires a multi-method. See, relating to woman question, there is a about the protection of interests of women. Suppose such questions are raised, whether related to marriage, related to a victimization, or in application of a criminal law, or so many other factors. When such questions are raised, then they have to be answered, they have to be examined from a different perspective. It is not the usual method, but a pro-woman approach is essential in asking the question, collecting data, treating the witnesses and arriving at inferences. Similarly, archaeological research, of course, we are not concerned with the general archaeology, but legal issues might be so closely connected with the archaeological issues. For example, Rama Janmabhoomi issue involved archaeological come legal issues. Then same is true about Gyanavapi Masjid or various other places. And so many other instances are there about protection of monuments or preservation of sculpture or artwork, etc. And in all those circumstances, along with the law, how social factors are taken into consideration. All this involve application of multi-method. Multi-method research is also called as a triangular method of research. There's a one will be drawing lines from different positions. Suppose about the borderline between two neighboring lands of two farmers, there is a dispute. Then the surveyor will be taking into consideration the lines drawn from different survey stones, so that by triangular application of the whole of information, the surveyor will be able to identify whether there is a encroachment by the farmer A or farmer B, or what is the exact line between the lands of farmer A and farmer B. See here, the surveyor will be taking the measurement from various survey stones, from ABCD number of stones around, from different corners he will be drawing such lines. In the same way, here in a multi-method research or mixing of methods, the researcher has to draw information from different viewpoints, and of course let all the truthful facts come from all sides. That is the principal approach. See, the researcher has to properly plan which method is appropriate for which type of legal research. Now, suppose about the issue of say compliance with the Criminal Procedure Code's prescription that a rape trial shall take place within two months. Which method of research could be regarded as appropriate? Mere historical approach alone will not be sufficient. Then mere analytical, once again inadequate. Mere comparative, also inadequate. So there is a quantitative research or qualitative research along with that, or feminist research questions are also asked. Then of course it will be used. It will enable the researcher to arrive at an appropriate conclusion. That's why the science of methodology should address this issue. Which method is appropriate for which type of legal research? And for all types of legal researches, one single umbrella of research cannot be regarded as something adequate, or one specific tool of research or one specific method of research cannot be regarded as something universally good for all types of legal issues. With this I am concluding. If you have any questions, you can pose questions. Yes.
So, as we progress in our research and we come to the final year or even later, is it possible to add more kinds of research, change the design and keep doing that if required, or if it progresses for a longer period, the research? Is it possible to change the such things and include more?
See, research is a process in a continuum, and one need not be a slave of a method. One need not be just sticking to specific method throughout. And if for the better output of his research work, suppose research design is to be altered or a different mode is to be adopted, the researcher need not hesitate about such a change. He can go for such changes.
Thanks.
You have a question? Okay.